This moment. 13. You got a great. We have an Alabama. You know when you outside of you like to say it. First, never know official metrics. You just declare it. We did that by here. But that's another scandal.
Yeah, for 30.
Actually like like the best thing.
Have you watched on 7?
Yes, I know. Yeah.
Okay, thank you.
All right, everybody. Good afternoon, friends, and thank you for joining us today. We are proud and honored to welcome former Attorney General Jeff Sessions to speak with the Georgetown Law Federalist Society. In addition to a remarkable legacy of public service, he has been a tireless champion for the American people and the rule of law. Jeff Sessions served as the 84th Attorney General of the United States from February 2017 until November 2018. He also served as the United States Senator for Alabama from 1996 to 2017, where he focused on maintaining a strong military, upholding the rule of law, limiting the role of government, and providing tax relief to empower Americans to keep more of their hard-earned money. I think we all like that. Sessions' distinguished legal career started as a practicing attorney in Russellville, Alabama, followed by a 2-year stint as Assistant United States Attorney for the Southern District of Alabama. President Reagan then nominated him to serve as United States Attorney for the Southern District of Alabama, a position he held for 12 years. He was elected Alabama Attorney General in 1995 and served as the state's chief legal officer until he entered the United States Senate the following year. Sessions attended Huntington College in Montgomery and received a Juris Doctorate degree from the University of Alabama. Sessions further served in the United States Army Reserve from 1973 to 1986, ultimately attaining the rank of captain. Sessions was born in Selma, Alabama, and is the son of a country store owner. Growing up in the country, Sessions was instilled with core values: honesty, hard work, belief in God, and parental respect that continue to define him so well today. Sessions and his wife have 3 children, 7 granddaughters, and 3 grandsons. They're all fortunate to have him as a grandfather. The American people are fortunate to have such a fierce defender of their liberty and such a strong advocate in their corner. Attorney General Sessions has set a gold standard that all public servants should emulate. Please give Attorney General Sessions a very warm welcome.
Thank you all. It's good to be with you. I don't do a whole lot of talking, but you can't say no to Brady. Keeps on. I like it. And I understand you have like 100+ members in the FedSoc here. I was at the University of Alabama not long ago, and it was over 100. That wouldn't have been true 15 years ago. Not here either, was it? So this has been, I think, a growing movement of great importance, and the events, the debates, the discussions, the speakers that you have is very important. I think the FedSoc has really accomplished things that I find almost impossible when I was your age. I could tell then that we had a very different view. Well, there was a very different divide in the country over the role of courts and law, and I was on a different side. I noticed that Governor of Texas, what's his name? I've got it down here, but he did a participate in a FedSoc event, and he talked about the time, which must have been 10 years or more after my time, in constitutional law class, when he really realized that there were 2 questions, 2 ways of thinking about law. He was very frank about it. You know, Texans are that way. He said on one side are the social justice warriors and anti-constitutionalists. On the other side are those who believe in the rule of law. I happen to believe in the rule of law. So that sort of defines the way I felt in my constitutional law class. I was rather shocked, actually, at one of the meetings. We had a very well-known liberal constitutional law professor, and somebody said, well, what does the Constitution say about this? Maybe you've seen this. I want to ask you if you have. So he goes to the board and draws a big circle around with a big smile. And then he drew 9 circles within the big circle. And then he drew a circle around 5 of the 9. And he said the Constitution is what they say it is. Well, I don't think. I think he was, in fact, cynical about it, Randy. I don't think he was saying that, making a point. I think he was saying that the law was malleable. It's driven by politics and ideology, and whoever those judges are, whatever they think they get to do. And it struck me very deeply at that point, apparently, as it did Governor. So I don't know, how they say it was a living constitution. It's not a living constitution. It's signed a contract. The ink's dry on it. You know, they said we got evolving standards of decency. That's the way we need to interpret our laws. Like I said, the Europeans and global have to be considered in interpreting our laws, and that you couldn't define a law based on 17th century dictionaries. All that stuff was out there, and I served through a lot of it as a United States attorney, and then 20 years on the Senate Judiciary Committee. And I was engaged in it, good or ill. I mean, I was engaged in that debate. So So Fedstock has done something remarkable. You have identified talented young people, promoted them, and many of them have been appointed to the federal judiciary. And no one would have told me, would have made me believe that at this point in time, we're likely to have 6 textualist originalists on the U.S. Supreme Court. When I came along, Rehnquist was the only conservative on the court. And they were doing a lot of different things that were troubling to me. Of course, I think the Roe decision was clearly an activist decision. It was a political decision. The judge goes over to the Mayo Clinic and he gets advice from doctors and he says, the Constitution says what my colleagues at the Mayo Clinic says it says. Give me a break. That was not answered by the U.S. Constitution. Many dreamed that one day Roe would be reversed, but actually never expected it to happen. I think that we've made a lot of progress. President Obama, I was shocked when he is knowledgeable president on law. He said his test for judges would be empathy. Remember that? He said it repeatedly. And I'm thinking, and said on the floor multiple times, whatever empathy is, it's not law. It's more akin to bias. It's more akin to politics than law. It's what you feel, what your ancestry is. A wise Latina should not rule differently than somebody else just because of their heritage. Our goal in the American system is to follow the law faithfully, regardless of our personal biases. I remember talking with John Roberts before he came up to testify, and we talked about the goal of a judge to be a neutral umpire and not take sides in the game. You don't get to advance your political agenda because you're in a robe, right? That's why you wear a robe, to declare that you're impartial and will do things right. So that's the American heritage that has blessed us, trust me, to an extraordinary degree. Not long after Reagan got elected, Harding Carter, who'd been in President Jimmy Carter's cabinet, said on Face the Nation, they hired him like they always do, hire liberals on TV. And so he said, we liberals have to admit that we can no longer expect the courts to do for us that which we can no longer win at the ballot box. So it all comes down to, in my view, how the people of the United States honor, understand, respect, and are willing to defend the legal system, even if it irritates them financially or politically or ideologically. You have to be able, if the nation ceases to be willing to sacrifice to some degree, the individuals, to affirm overall the rule of law, then we are in pretty big trouble. And I think there are dangers out there in this new world of internet and technology and secularism. It's a worrisome time. So I could feel the problem in the Senate. I could definitely feel it there. Power, politics, and ideology tended to trump. Like a better word. That's good. To trump principles. Good founding principles that virtually all Americans had internalized and honored for almost 2 centuries, over 2 centuries, have been under attack today. Marxism, 1619, critical studies have challenged the very legitimacy of our founding. I want to talk a little bit about that. Are you keeping the clock?
Yes, sir. You got time.
If my wife was here, she'd be doing actually. So there were at the founding enslaved people, women lacked rights, Native Americans were mistreated. Any true history of our founding has to acknowledge that these were real failures and stains on our heritage. They just were. But what is missing, I think, in the modern evaluation of things is perspective. America didn't arise out of nothing. Do you expect George Washington to fix every problem then existing in the world when the Constitution was drafted? I don't think so. That's not very realistic. It advanced from, our government did, the English system, which was, I think, it most advanced at the time in the whole world. So honest history must tell the story from Jerusalem to Athens to Rome to London, and how real nations actually come into being, and why some fail and some succeed. Perspective allows us to honestly see that ours was an imperfect but a good family, and it was a successful. So it's a great story. How can we not tell it? But that societal consensus is being eroded today. I had a history professor at a history conference last week here in DC, and she just retired, but she said, young people today have to be gently brought to understand this kind of, because there seems to be an instinctive reaction on many that if you say we have a great country and a great founding, they tend to push back. I thought that was pretty serious, very wise lady, I thought. But that society, that consensus is being eroded. So I'm not going to talk about the details and the success of the Constitution in detail. I believe it was the greatest such document ever written. Name me another. It provides, but my concern today is that we're taking it for granted. We're not teaching it, and that produces indifference and ignorance. You're asking people to follow rules whether they want to or not. And they have to have a certain respect for the rules and the legitimacy of our constitutional order, or they're not going to be good at it. So my favorite painting in Washington, if you've been there, is the one of George Washington in Annapolis, turning in a piece of paper. I used to ask students when we would tour the Capitol, what was it? And they would say Declaration of Independence, which is the other famous painting. But this was Washington turning in his resignation as commander-in-chief of the Continental Army that had defeated the British Empire. The most respected man in the country. So the balcony and the room were packed. People were leaning over. Every eye was on the great man. December 23rd, 1783. Here, the victorious commanding general, turning in his resignation, like Cincinnatus, to return to his farm the very next morning at Mount Vernon, leaving the job of governing the colonies to the elected representatives, the civil authorities. That's a big deal. King George was reputed to have said, if he did that, he's the greatest man in the world, which I would say he was. Got to ask who was the greatest man of the millennium, like 2000. Washington was my choice. So he knew exactly the meaning of his resignation. He carried himself to convey a message, just the way he carried himself. And it is said that there was not a dry eye. Everybody knew what this meant. So something big was happening. Something big happened a few years later when the Constitution was written on September 17, 1787. So the people, a free people, had formed their government after this great war. We know the Constitution did not fix every problem. Washington lived in a flawed world, as we do today. They created, though, the most advanced liberal government structure in the history of the world at that time. And their work produced a government that would allow for a more perfect union to be established. In a monumentally historic decision, critical decision, they said the power would come from we the people, not from the king. Yeah. It was written to provide firmer protections for the people. It's the longest continuing constitution in the world. history of the world. Many have attempted to we went to Iraq and Afghanistan and did our best, and we had JAG officers and retired professors and people trying to teach this too far, but they are not culturally, organizationally, historically, educational, capable of doing this. So we were blessed to be in this place where we could do it, and they did do it. A government from Boston to Georgia before even the telegraph system. I think we got a lot to be proud about. And though the Declaration and the Constitution was not a failure, you can say that with boldness, firm strength. So we had educated realists who placed their lives and fortune, sacred honor on the line in the belief that a war for independence could be won. Certainly not certain, and the ideals they shared could form the basis for a new and better form of government, one that would endure. But they were thinking long term. They weren't thinking short term. The world was watching. Everybody was wondering, can these people put together a government, a republic, without a king out in this wilderness? Very few thought it was possible. I remember Henry Kissinger came to little liberal arts college. My wife and I attended in Montgomery. He defined the greatest quality of a leader as courage. And he defined courage. He said courage was the willingness to act on a set of beliefs that can't be proven at the time. What is that? What did our people do? I think they believed they could win. They believed they could write a better form of government. They committed their lives and fortunes and sacred honor to it. And they made it so, even though a lot of people put them down. And the founders were well aware of these cynics and these doubters in Europe and other places about their ability to be successful. They knew that chaos and passion lurked everywhere, and it had destroyed many, many governments. And they were well aware that our government was subject to failure. And they tried to write it in a way that would adjust for that. You know, it was said that Madison read every book then existing on the government before he came to the convention. Certainly he prepared himself for the convention with real historic knowledge. So they knew that getting this Constitution right would be a critical event. As Washington said, the Constitution is the guide which I will never abandon. And that was sort of the philosophy of people at the time. From the start, Americans before the Revolution were steeped in this British legal system. Edmund Burke, speaking to the Parliament, I thought it was interesting thinking about that the king had already decided to go to war against the colonies. And he and some others freely spoke out and opposed it on the floor of the Parliament. Brilliantly, really. His speech on reconciliation with the colonies, he declared the colonies were only insisting on their rights as Englishmen as they had been taught. He noted that more copies of Blackstone's commentaries of the laws were sold in the colonies than in the mother country. A recent National Review article by Dan McLaughlin gives some insight, and he notes that in Common Sense in 1776, Thomas Paine wrote, "As in absolute governments, the king is the law. So in free countries, the law ought to be king." State of Massachusetts, 1780, during the war, concluded its new constitution with these words, "All to the end that it may be a government of law and not of men." The famous Marbury Madison case, 1803, Chief Justice Marshall wrote, "The government of the United States has been emphatically termed a government of laws and not of men." No citation need be made for that fact. And it was growing outside, this movement outside Boston, for example. 10 years before Lexington, Gadsden in South Carolina opposed the Stamp Act, saying it was inconsistent with, quote, the inherent right of every British subject not to be taxed, but by his own consent or that of his representatives. I chanced upon recently, I'm sure many of you know, heard of the story of William Henry Drayton. He was appointed a judge to Western South Carolina because they were having violence and disruptions. He was to bring order to create a grand jury, dig into the crimes, and he gave them a charge that became pretty famous. He charged his grand jury that you are authorized to pass judgment in this first instance upon the apparently guilty wretch, and by your acquitting voice to shield apparent innocence from malignant prosecution. That's the way grand juries are still done today. America, with language not too far from that. And they are to do so, he said, with fearless integrity. As an Englishman, he charged, this is 1775, you should prefer a generous death to servitude, to hazard everything to maintain that rank which is so gloriously preeminent above all other nations. You ought to endeavor to preserve it, not only for its inestimable value, but from a reverence to our ancestry from whom we received it, and from a love to our children to whom we are bound by every consideration to deliver down this legacy, the most valuable that ever was or ever can be delivered to posterity. Okay, so you say, well, he's a loyalist. There were a lot of lawyers. He goes on to say, this liberty is compounded of the most generous civil liberty that ever existed, but without our pious and unwearied endeavors to preserve these blessings, it is folly and presumption to hope for a continuance. Then he goes on to say he wasn't so loyal to the crown. He said, I'll tell you what your rights are as Englishmen. Quote, English people cannot be taxed. Nay, they cannot be bound by any law unless by their consent expressed by themselves or their representatives of their own election. He notes some judges like to style themselves as the king's servants. He then declares, but for my part, in my judicial character, I know no master but the law. I am a servant not of the king, but of the law, but of the Constitution. So we got to teach this heritage, I really think. And it's a dicey time we're in. You all live in it. 24-hour news and all the things that happen. And the Constitution has centered us. It needs to hold. People think we can't allow our liberties to slip away. You're mistaken. History teaches otherwise. And so the president's judges take an oath to serve under the Constitution and laws of the United States. I used to like to quote that when we were debating judicial activism. You're not above the law, you're under the law. We pass the law, you order it. The president swears to protect and defend the Constitution of the United States. The senators swear, I will support and defend the Constitution against all enemies, foreign and domestic, and I will bear true faith and allegiance to the same. Well, that's the way we were centered. We need to grasp this. So it's a good heritage, I think, ladies and gentlemen. It falls our lot to preserve, protect, and defend it. You young lawyers to be, it's a burden on you. I hope that you will take seriously the privilege, the glory of being a part of this legal tradition, that you will recognize its uniqueness, its value, and preserve it as time goes by. Now, great. I said I would try to answer some questions, but I had 20 years in the Senate, so I'm pretty good at dodging questions. If you'd like to do that, I'll be glad to.
Yeah, I think we could. Great to kick off and I think if you don't mind, I might steal the first one here, but do you think our political system today is faithfully serving the rule of law and the American people? And if not, what needs to be done to get back there?
Well, I gotta tell you, pre-FedSoc, I didn't think so. I was very worried of the respect for law. But I think when you get 6 originalists on the Supreme Court and we got talented judges all over the country and they're writing persuasive opinions and even influencing their colleagues who might not have given much thought to this because of the power of their opinions and the integrity of their opinions, I'm kind of feeling pretty good, but we don't need to lose public support. I mean, I wish we conservatives had done a better job of explaining that Dobbs' decision was not a political decision. It was a restoration of correct constitutional principles that had been violated by Roe, clearly violated. The Constitution didn't say states couldn't have a law about abortion. Give me a break. This was pure power. And we had the time, about that time, Brennan and Marshall started descending on every death penalty case after years of fights. And they took the view that the Constitution said the death penalty was unconstitutional because it was cruel and unusual punishment, which is ridiculous. I mean, there were like 8 references in the Constitution for the death penalty. You can't do capital crimes and take life without due process. All kinds, every state had a death penalty and the United States government had a death penalty. They're going to waltz in there. They thought they were on the tide of history and it was just a matter of time and they were going to win this thing. But that's the kind of thing I think is a threat. When you got judges openly rejecting plain authority. So I think we're better. Yes.
Growing up when you did in Alabama in the 50s and 60s, there was a lot of legal upheavals that had a really big impact in Alabama between the civil rights stuff and even the Supreme Court rulings on like religion and public education. How did that legal turmoil shape how you view the law and what you think the constitutional order, how it should look like?
I think fundamental that Judge Frank Johnson, for example, who was so prominent in Alabama, great judge, but he drove the judicial agenda, and it basically found, like Roe, that separate but equal is not legitimate. It's not equal, and it's not equal. And so that was a huge change. And it took some bold and aggressive judges who issued injunctions and things to rectify a lot of the problems that then existed. So I think in some degree, the progressive ideology moved from that to a view that we're pretty unlimited. But Frank Johnson's view was not unlimited. It was reforming a illegal, immoral system of segregation. I just like to say sometimes people forget, but when my wife and I in the 60s formed the Langdon College Young Republican Club, we were against the George Wallace segregationist standing in the schoolhouse door. And for a decade, he and his team basically won elections. But over time, you know, the South has become a conservative state. So I guess I'll go to the next question. That's it.
First of all, I appreciate your reference to Kirk's Roots of American Order. I really like that book. But so even though there's 100+ people here in FedSoc, we're still very much a minority on campus. I think that's true for conservatives across the country. And higher education, I feel like it's been hijacked by globalists or cynics or what have you. So my question is, what advice do you have to conservative students in this echo chamber environment, syllabi look like propaganda, there's censorship from administrations. And do you think that there's any sort of reform that has to happen in higher education?
Yeah. Oh, I think Last week I was at the American Council of Trustees and Alumni, and they're giving the most of my civic time I've spent on trying to ensure we're teaching good history and good law. And I think that Reagan helped found ACTA, Ashbrook Center also, and John Jack Miller Center and Hilldale College, and there are a lot of people that are advocating. But I told my friend who was at a very liberal university, probably more so than this one. I think this one, Randy, professor, tells me that you can speak here. That hadn't been true in some places. I know some of the Ivy Leagues have been hostile to FedSoc, made it hard for them, really, still is. Yale, maybe. So I think you should take advantage of that. Number two, how it is that the taxpayers, I guess not Georgetown, but taxpayers are funding universities with 80–90% of the faculty leftists. And so you talk to students, they say, oh, we got a nice professor. He was nice to me. I mean, don't get the Stockholm syndrome. You're an American. You got the right to free speech and defend your beliefs. And if you have doubts about your own view, quote Scalia or something. I mean, it's perfectly good to have liberal professors, and I'm not saying that we need to bring, but I just think that the universities cannot ignore the great legal revolution that's occurred, where great scholars, legal thinkers have rethought and reaffirmed the founding principles of it. So y'all don't back that.
You mentioned what you view as activist decisions. What role do you think stare decisis should play when the court's looking at a decision that, maybe was improperly decided or was judicial activism, but it's been around for a long time. It's pretty baked into our society. Obviously Dobbs, but even like less controversial decisions, Dobbs, like Saker's Wolves.
Yeah. So before all Dobbs, Chief Justice Roberts came before the Judiciary Committee, and they asked him about stare decisis. And he just did this 15-minute run. These judges, this case held such and such, and this one held such and such. It was 5-4 here, and Justice Brennan said this, and Justice Berger said that, and all this. I mean, we're just sitting there. This is unbelievable. But there are principles, as he laid out. You could get his remarks, but about where you should not overturn well-settled precedent in times when it's appropriate to do so. I mean, it was appropriate to overturn separate but equal. And so that was the first thing. Is a fabulous Christian magazine, if you have any interest. You're a believer. Rusty Reno had a forum for people to write about before Dobbs. Bobby George at Princeton, and I don't know who all was there, but I was really interested. Good. But the basic, Bobby George said, American people have patiently marched, voted, elected, campaigned. They have a majority on the Supreme Court. Everybody on that court knows Roe versus Wade was wrongly decided. You have to do your duty. So that's kind of the way it was. They had to do their duty, regardless of politics. Maybe it's made abortion more accessible. Votes have been going different ways, but as a matter of law, to have betrayed the people who worked to elect presidents who appointed judges, I think was just something, a cup they couldn't fail to drink from. Yes.
So you detailed how the originalist project has been at least somewhat successful in repelling attacks against the constitutional order from the progressive left. How do you think it will continue to function now that it is also being attacked by some members of the right for not going far enough, for not being politically conservative?
I think this is a very good, I think this is really important. I'm a little uneasy about that. In other words, there seems to be one friend, or at least I know, wrote an article in which he suggested it might be time to cross the Rubicon. Look, I understood, I didn't mistakenly understand what he was saying. No. Our system is not so bad that we need to be thinking about that. So I think we should push back against people from both sides. And it's unfair to attack this textualist, originalist court for being active. I think they're fundamentally neutral umpires deciding questions as they're compelled to under the law. We should defend them. We should have done, I think, FedSoc and a lot of other people should have defended the court more effective. And the Dobbs decision. I think keep an eye on that. Some of your conservative buddies start going too far. And look, in the long run, when I went to the Department of Justice, and Julie back here knows about that. But we were committed to the view that the Department of Justice had gone too far in politics, and that we need to restore law. That even though you lose this battle because the law is against you, you're strengthening the foundations that allows you to have a level playing field and to preserve the strength of the republic. And if the more you chip away at the integrity of the law, then the whole thing can fall. Professor Van Alstyne at Duke, he considered himself a liberal. One time he said in the committee hearing, well, I've been at this a long time, and for me, I've concluded that if you really respect the Constitution, you will enforce it as it's written, the good and bad parts. Judges start, or politicians start erasing things they don't like in the Constitution. It weakens the whole structure, and our liberties become at risk. Yes, sir.
On the, speaking of the Department of Justice, how much, I don't know, you have some expertise in this, I would say, how much independence do you believe the Attorney General and the department should have from the president, if any at all, from like a unitary executive perspective? And how do you think the president and the Attorney General should balance each other's interests?
Well, you know, I was a U.S. attorney for 12 years. Rod and I were he said only about 5% ever served that long, and assistant 2.5. And I've been on judiciary 20 years. And I'm a firm believer in the unitary executive. I think Bill Barr, when he was, first time he was Attorney General, wrote something like that. And it adheres to the view that the people elect one person to run the executive branch. And they don't give powers, or great powers, to individuals for whom they have no ability to vote and elect. And are not accountable to anybody, really. So I'm a big believer. So, but it was really easy for me. This was really easy for me. Oh, you had a hard time over recusal. It wasn't hard. You give the president, you support his political agenda, his legislative agenda, you help him craft it so he can get it past legal challenges. You try to help him advance, and I believed in the agenda. I believed in the agenda of the Trump administration more than anybody else in his cabinet. I've been talking about it before he got elected. And so, but people, if you believe in the American legal system, you have to defend the integrity, and you can't preside over a case in which you are a party, or a case in which you were an officer in a corporation. The Trump campaign, I was an officer. I was reported to the election commission as an officer in the campaign. I can't then supervise an investigation of my campaign. And we had actually some specific DOJ regulations on campaigns also that answered this question, but I didn't need that. I mean, everybody knows you can't. So the DA can't prosecute a corporation that he was an officer in. But anyway, I do think that's where it is. So there are things you can't do, but it's absolutely true that the Attorney General and the Department of Justice, prison system, the FBI, the DEA, all of that is part of the executive branch. And the chief executive is the president. And some Milley and some Barnum or whatever from Ukraine doesn't get to set Ukraine foreign policy. The commander in chief sets the command. This is so big, it's just amazed. So some of the things they said and did, I mean, this is just fundamentally incorrect. I don't care whether you disagree with it or not. You can resign or you can just do it anyway. But you can't keep in office and oppose the decision of the commander in chief.
General Sessions, I have a question about that, managing the department. You had a department of maybe 110, 120,000 people.
One who served in it.
Yeah. And so you had your staff in the AG's office. We had our staff in the deputy attorney's office. You had 90 political appointees. There were 90 of us out of 110, 120,000 people. How do you control a department filled with tens of thousands of career employees, many of whom oppose the agenda of you or the president of the United States? How do you get your arms around a department with 90 political appointees when you're supervising tens of thousands of career appointees?
That is a very good question. I mean, it's a very good question. And it's in many ways not doable, but there are things you can do. We did. We stepped up crime prosecutions, or we rejected the defund police. We all of that stuff. We took a number of positions on controversial issues. We intervened in the Harvard DEI case, several others of importance to advance what we thought were appropriate views. But one of the people this morning at the hotel spoke to me, said, "You used to be my boss." I said, "Really?" He said, "Yeah, I worked at the Bureau of Prisons." You think I know what the Bureau of Prisons was doing? I mean, I knew more than most because I'd been a United States attorney. A lot of these people hadn't even been in the Department of Justice to become attorney general. They are very vulnerable. So I think we need to strengthen the ability, and I'm not sure how, of a president to carry out his agenda and to be heard by the bureaucracies. Else you don't have a democracy. You've got some sort of French-like immovable apparatchiks who run the government no matter who gets elected. I think it's a big issue. Yes, sir.
I wanted to ask you about the Masterpiece Cake Shop case that you were involved in. So I know the Supreme Court in that case did not definitively rule on whether or not businesses can refuse service based on religious freedom. So I just want to get your thoughts on that.
Well, we intervened in that one. We filed amicus type brief, what do you call it, statement of interest, I believe. There's a specific statute that allows the Attorney General to intervene. I filed a friend of the court brief. So we did, defending the cake baker. There was a real sense of that we should advance a position that had the highest likelihood of winning, which, and so our brief did not go as far as I wanted it to go. They're smarter than I was, so I agree. I went along, but we won the case as our lawyers thought it would. No, I thought it would. And so I was pleased to join that. I think this is amazing that the government can force someone to produce a product for a celebration they don't believe in. I mean, it's a world. Who cares? Somebody will make a cake for you. I mean, you know what the hell? This is kind of stuff that's out of. I am pleased. So we wrote a policy for the department and actually all government agencies. It was adopted by the president, but we wrote it at the Department of Justice that protected religious freedom and barred a lot of the activities that previous administration were using to suppress legitimate, free religious expression. I don't think they reversed that one. I think they reversed the one on nationwide injunctions, didn't it? I was, Professor Barnett invited me to speak at a controversial time, and I gave a speech. That was the one on nationwide injunctions, I think. Yes, nationwide injunction. I was complaining that a judge sitting on a pile of rocks in the middle of the Pacific Ocean didn't have the power to enjoin the entire United States government on whatever he or she thought. That caused a little controversy. But so you were getting these individual district judges coming up. So we issued a policy that quoted at length the Supreme Court and other ideas about it. But most of those policies, they just reversed on day one. I don't think they reversed the religious liberty one yet.
So I'm curious, based off your time in the Senate and all the judges and justices you've seen go through the confirmation process, how do you think that's changed since you've been there? And I'd be really curious to know your thoughts on specific like Supreme Court reforms that some they're advocating for and how that was recently.
I think it'd be a major politicalization of the courts to add judges so you can get a political result. We've been living, conservatives have lived with a long-term activist court, but at first I think that's a big deal. We had some great hearings. Roberts was so fabulous. Just a tutorial on whatever you want to ask him. But he was the premier appellate lawyer in America. I mean, this wasn't, so he knew what he could talk about. So there followed Alito. Nobody knew much about Alito, but I liked him a lot. And he was so good. Lindsey Graham came over to me and said, "My God, he's better than John Roberts." So I told I was chairman of a court subcommittee, and Roberts would invite us over to sit by, and talk to his judicial conference. And I told that story. I think most of the judges really liked it, but I'm not sure Roberts did. Because he was fabulous, I gotta say. And so I was chairman, ranking Republican. We were in the minority when Kagan and Sotomayor came up. I thought we did a very good job. To me, if a judge can't assure the Judiciary Committee that they will be faithful to the law and their oath to serve under the Constitution and laws, then that's a disqualification. So if somebody came in and bragged about being empathetic, I'm going to bring my empathy to the court, and that's how I'm going to rule. I'm not sure about that. Or I'm a Latina, and I want to I'm gonna rule like Latina law says, however I feel. This is not good. So we had good hearings on those. They both got through, Kagan, Justice Sotomayor. She was telling me about her mama and how she grew up and all that. Did she go to Harvard or Princeton? Harvard, I think. So I said, well, George, if you would just vote like your mama taught you, instead of what Harvard taught you, you wouldn't have any problem. So in some ways, I think it's that the pivotal moment was after Bush v. Gore. And the Republicans voted 5-4 to, in effect, give the election properly to George Bush. And they had a meeting. Cass Sunstein, Lawrence Tribe, and the Democratic leadership, Schumer was a big part of it. And they announced they were changing the ground rules of confirmation. And before then, there were holes placed on nominees and some of them drug out for a long time. But nobody firmly announced that it was the policy of the Senate to filibuster an otherwise unqualified nominee. So, and they started filibustering. I think it was 14. They filibustered every one of them. They affirmed 2 Democrats that Bush renominated their nominee. Boom, boom. And then they blocked everybody. And it went on for weeks, and the gang of 7 or 14, Lindsey Graham and John McCain, but it took a threat by Bill Frist to say, we have the power to confirm a judge. We will execute the power to confirm a judge over a filibuster with 50 votes, 51 votes. Then they started talking in the meeting. So they let about 8 of the 14 go through. One of them being Bill Fine, used to work for me in Alabama, and now the chief judge of the 11th Circuit. Lindsey Graham said, man, if he can't be a judge, nobody can be a judge. But Lindsey was on the committee, not me, and he would, when they could give it up, who would get through and who wouldn't get through. Judge Pryor.
When you were on the Senate Judiciary Committee, I guess, what did you view as your role and the Senate's role in evaluating judges? Was it to assess legal qualifications, moral character? Was there a political or a partisan element to it? Like, what were you looking for, and what do you think the Senate should be looking for?
I think my view, and most of it, Hatch and all, Hatch was a little more deferential to the president than I, because he'd grown up at a time when everybody got confirmed, basically. So the thing came down to what are you saying precisely there? How did I view it?
Or how do you think what do you think the Senate should look for in a nominee when they're making decisions?
Well, I developed my own philosophy. I've been being very serious about thinking about it for years. And it was that if I don't think a judge has a judicial philosophy that would cause them to rule according to law, even if they didn't like it, even if it wasn't their personal opinion, then I think they're a rogue judge. And so if they've got writings that say things, so Sotomayor had quoted Professor Martha Minow multiple times in a speech where Minow had said, there is no objectivity, just a series of perspectives. I'm not sure anybody else thought that was as dangerous as I did. I thought it was very dangerous. It was a key reason I didn't support her. I voted for more judges, Democrat judges than opposed, for sure, way more. But, so you can't demand that Democrat, I don't think. There's certain courtesies that Democratic presidents get some deference to who they nominate. And Republican presidents should get some deference. But what are the minimum standards that you're faithful to the Constitution and law? I think you have to show that you have a certain degree, high degree of integrity. One of my federal judge, so great, I used to call him every time in Alabama about who would be a good nominee, and he would always say, the first thing is integrity. If they got integrity, everything else can work out. But if they are always manipulating, maneuvering, you don't want it. That's an integrity question, I think that's.
We're in. All right, guys.
Good to be with you. Keep battling. You're free Americans.
Attorney General, what an honor.